A Treatise on the Law of Notice as Affecting Civil Rights and Remedies by William P. Wade. Chapter 2, Part 2b, Section 208. Record imparts no notice of relations between parties. The constructive notice by registration does not necessarily imply knowledge on the part of subsequent purchasers of the relations subsisting between the parties to the recorded instrument. So where a mortgage was given by A and B on several pieces of land owned by them in severalty to secure their joint note, which was executed by B as surety for A, and subsequently A gave a second mortgage on his land, and B, by reason of his being surety for A, claimed that he was entitled to pay off the first mortgage, and B subrogated to all the rights of the first mortgagee for his indemnity, thereby taking precedence of the second mortgagee. It was held that, as the record imparted no constructive notice of his suretyship, and actual notice thereof was not proven, innocent purchasers or encumbrances could not be affected. Section 209. Recitals of material facts held not to be noticed. It has even been held that the record is not always constructive notice of all it contains material to the title, as where there was a recital in the body of a deed which disclosed the fact that a prior mortgage had been given on the same premises, and such mortgage was unrecorded. The recital was not treated as constructive notice to subsequent purchasers of the existence of the mortgage. Section 210. Example of broken chain of title. In a recent case where there was an outstanding unrecorded deed of the premises and a deed duly recorded from the grantee to another person, and also a deed from this other person to still another, which last was likewise recorded, it was sought to charge an innocent purchaser by the record of these two deeds with constructive notice of the prior unrecorded deed. From the report of the case, it seems that before completing the transaction, the purchaser sought to be charged obtained an abstract of the title, in which both these conveyances, the one from the grantee in the unrecorded deed, and that from his grantee, were mentioned. It further appears that in neither of these was there any recital of the unrecorded instrument which formed a necessary link in the chain of title. It was held that the conveyance appearing of record did not operate as constructive notice of the unrecorded instrument under which they both held, but in reaching this conclusion, the court intimated that the case might have been differently decided had there been a recital of the unrecorded instrument in those appearing of record. It is impossible to gather from the report of the case cited whether or not the fact that the purchaser had been furnished with an abstract of the title was insisted upon as actual notice. What seems to have been in dispute, however, was whether the record of the deeds from parties who, for all that appeared of record, were strangers to the title, was constructive notice of the unrecorded deed. In cases where this issue alone has been raised, it has been almost uniformly decided that even the recitals in detached instruments, however explicitly they may refer to prior unrecorded instruments affecting the title, will not charge subsequent purchasers with constructive notice of the facts therein recited. Section 211. Example of contrary doctrine. The views expressed by the court in a still more recent case seem to be directly at variance with the weight of authority upon this question. The controversy lay between the plaintiff claiming by adverse possession under color of title and defendant, a purchaser at an execution sale. The plaintiff held a deed, duly acknowledged and recorded, from a purchaser at a prior execution sale. In attempting to execute the deed to the first purchaser, the sheriff omitted to affix the seal or scroll, which was imperatively required to give validity to the deed. This omission, the court declared, rendered the deed a nullity. And being an attempted execution of a statutory power in derogation of a common law right, equity would not aid its imperfect execution. It was not the conveyance of an equitable interest as it would have been had the deed been a voluntary one, and the seal omitted by mistake. The void deed, however, was copied upon the records before the purchase by the defendant, as was also the deed from plaintiff's grantor. It is not clear from the report of the case whether the defendant, prior to his purchase, had ever seen the record copy of the sheriff's deed, but the court held that as the deed to plaintiff recited the former judgment, execution and sale described the land correctly and stated that the first sheriff's deed was executed. It was sufficient to put defendant upon inquiry, which would have resulted in a knowledge of plaintiff's claim, and was consequently constructive notice to him. Section 212, the above criticized. The views expressed by the court in this case seem irreconcilable with those previously expressed by the same and other courts upon any other hypothesis than that the defendant had actual notice of the record. The case might have been decided by leaving entirely out of consideration the question of constructive notice by registration and resting upon plaintiff's adverse possession, which seems from the instruction reported to have been the view taken by the court below. If it is true, as we have seen, that the record is only constructive notice to those claiming to purchase under the same grantor, the record of the plaintiff's deed could not have been constructive notice to one purchasing at the last execution sale, because it was from one who, so far as the record disclosed, was a stranger to the title. Neither its recitals nor the unauthorized record of the void sheriff's deed, nor both these together, could connect the plaintiff's deed with the title of the judgment debtor under whom the defendant claimed. The deed from the purchaser of the first execution sale was properly recorded, it is true, but between it and the title of the judgment debtor there was a blank. In order to make the record of its recitals constructive notice, the same operation must be given to the record of the void deed as to a valid one, or else there is nothing to lead the searcher of the records to a knowledge of the fact by which he is to be bound. Section 213, Sheriff's Deed from Apparent Stranger. The record of a deed from a sheriff pursuant to an execution sale will not be noticed to a subsequent purchaser when the title acquired by such subsequent purchase is derived from a different source, and there is nothing appearing of record connecting the execution debtor with the title, as where certain land was paid for with the money of a judgment debtor, and at his request conveyed to another in trust for his wife for the purpose of defrauding his creditors, and the land was sold on execution against the husband, and subsequently purchased from the trustee and the wife, by one having no actual notice of the equity of the husband or of the sheriff's sale, the record of the deed from the sheriff would not charge such subsequent purchaser with constructive notice of anything by which his title might be affected. Section 214. Record of conveyance anterior to grantor's title. The purchaser is not charged with notice from the record of conveyances from his grantor prior to such grantor's acquisition of title. In such case, the subsequent purchaser would not be estopped by the record of a mortgage from his grantor prior to the date of his grantor's deed. To hold otherwise would be to impose upon the purchaser the duty of examining the records indefinitely. Section 215, illustration of same. So, in a case where a tract of land was conveyed by deed to A, with the exception of a certain lot included in the general boundaries, and the deed was duly recorded, after which A mortgaged the entire tract to B, this mortgage was also placed upon record. Subsequently, A purchased the lot. C held a judgment against A. The entire tract was sold to satisfy the mortgage claim, and the lot was sold to satisfy the judgment. In a contest between the purchaser and the mortgage sale, and the purchaser and the execution sale, it was held that the latter, by his purchase, acquired the better title to the lot. He was only constructively notified by the record of encumbrances placed upon the lot by the judgment debtor, subsequent to his acquisition of title. Section 216, Contrary Doctrine Criticized. The doctrine of estoppel by deed was applied to a case similar to the foregoing, and it was held by a divided commission that the record of a mortgage prior to the purchase of the premises by the mortgagor was binding upon privies in blood, privies in estate, and privies in law, after the title was acquired by the mortgagor. But upon both principle and authority, it seems more consonant with the spirit of the Recording Acts to absolve purchasers from the duty of examining the records for conveyances from their grantors prior to the time when they had a title to convey. Section 217. Purchaser from heir without notice of ancestors, unrecorded deed. Where the grantor of real estate dies and the deed is not recorded, it has been held that a subsequent purchaser from the heir for valuable consideration and without notice of the unrecorded deed would be protected to the same extent as though he had purchased from the ancestor under similar circumstances. Section 218. Reasons assigned for the rule. The following are the principal reasons assigned for this holding. The heir stands in the shoes of his ancestor. The title to the real estate descends to him immediately on the death of the ancestor. When the purchaser ascertains who is the sole heir, he would ordinarily be willing to treat with him much as he would have treated with the ancestor in his lifetime. It is true that the heir could not hold the property as against his ancestor's grantee, whose deed was unregistered. In this respect, he is in neither a better nor a worse condition than his ancestor while living. If the real estate of which one dies, apparently seized, is to remain forever subject to unrecorded instruments affecting the title, the benefit to be derived from the registry laws is utterly lost as soon as the title is east by descent. If one hold a deed to land which is unregistered at the death of his grantor, unless subsequent purchasers from the heir are protected, the same as subsequent purchasers from the ancestor, it need never be registered in order to protect the grantee's title. It is believed that it was never intended by any of the recording acts that the death of a grantor should be allowed to create a break in the chain of title, as it appeared of record, and protect the grantee whose deed was unregistered against subsequent purchasers without notice. The only question is whether a contrary intention is sufficiently expressed in the statute. Section 219. Reason assigned for contrary doctrine. It has been held that the grantee of the heir will not be protected in his title against the chain of the ancestor's grantee or mortgagee whose deed or mortgage is unrecorded, because the language of the statute does not warrant such an interpretation, though it is admitted that a purchaser at administrator's sale who has his deed first recorded will be protected against claims under prior unregistered instruments. It is said the heir has nothing to convey. Section 220. The rule is sustained on principle. The language of the statute usually is in substance that no instrument affecting the title to real estate shall be effectual as against any persons except grantors and their heirs, unless recorded in the manner prescribed. It is argued in those cases where protection is denied to innocent purchasers from heirs that the title passes by the execution and delivery of the deed and not by its registration. Therefore, the ancestor, having divested himself of all title to the premises during his lifetime, at his death nothing descended to the heir which he could convey. By the same rule, no title remained in the ancestor which he could convey. Yet, if he attempted it, the subsequent innocent purchaser, by the exercise of proper diligence in filing his deed for record, could secure the title. Section 221, Kentucky Authorities. In the case of Harlan v. Seton, the court does not attempt a vigorous defense upon principle of the position assumed, but virtually yields to the doctrine of stare decisis. Early decision of the same question by the same court are allowed or followed for the declared reason that they have established a rule of property in that state, and it is deemed better that the law should remain permanent, even though originally settled upon doubtful principles. Section 222, Weight of Authority and Governing Principle. As between these conflicting views, the weight of authority seems to be in favor of extending the same protection to bona fide purchasers from the heirs of a deceased grantor, where the prior deed is unregistered, as is afforded to subsequent purchasers from the grantor himself. This view seems also to be supported by the better reason. Following the record as a guide, the title seems to be in the heir at the moment of the ancestor's death. It is true that as against the ancestor's grantee, he has no title at all. But the same could be said with equal truth of the grantor himself, where the subsequent deed is from him. It is probable, however, that the courts of each state where the question has been once decided will generally adhere to its own construction of the statute as best calculated to ensure permanency in the laws governing property. Through the case of Youngblood v. Vastine, being the latest decision of the court where it was decided, flatly overrules the earlier cases cited, in which a contrary view is expressed by the same court. Section 223. Record of conveyances between strangers does not affect purchasers. The record of a conveyance from one stranger to the title to another does not affect a subsequent purchaser who claims under a different grantor. A fair illustration of this doctrine is found in the case of Blake v. Graham. In that case, there had been an unauthorized deed executed by an executor in Pennsylvania of lands in Ohio, which deed was recorded in Ohio, but it was held to be of no avail as notice to purchasers from the heirs of the testator. Section 224. Effective record of instruments affecting chattels follows property. Antenuptial contracts of such a nature as to be binding upon the parties, affecting the title to chattels, when properly acknowledged and recorded in the state where the property is situated at the time, have been held to follow the chattels when removed to another state, and operate as constructive notice in the new locality. So where personal property is mortgaged in one state according to the laws thereof, and duly recorded, the rights of the mortgagee are preserved after the removal of the property to another state. Section 225. Time given for the registration of deeds. Where the statute prescribes a time within which the deed to be operative as notice to subsequent purchasers shall be filed for record, it is given a retrospective effect from the date of filing, if within the prescribed time, back to the date of the deed, and is held to take precedence of instruments of subsequent date, even though the latter be first filed for record. The same advantage, however, is not always accorded to mortgages and deeds of trust, as those are held to be constructive notice only from the time they are lodged with the proper officer for registration. Section 226. Must be purchaser for value. It is not everyone who may be technically styled a subsequent purchaser that will be allowed to take advantage of the fact that a prior deed to the same premises is unregistered. It is not sufficient that he is a purchaser without notice. He must also be a purchaser who has parted with value. Section 227. Assigning for benefit of creditor. In thus restricting the operation of the statute, it has been held that an assignee for the benefit of creditors is not a purchaser for value, and therefore such an assignment would be postponed to a prior unrecorded mortgage. Section 228. Creditor purchasing at execution sale. And so where at an execution sale the creditor was the purchaser and the amount for which the purchase was made was credited on his judgment, it was held that he was not a purchaser for a valuable consideration and was not entitled to the protection of the registry laws. Section 229. Purchasers at execution sale notified by registry prior to sale. But whoever is the purchaser at execution sale, whether he be a creditor or not, is charged with constructive notice of all instruments affecting the title, executed and delivered by the debtor prior to the judgment and subsequently recorded, provided such instruments are recorded prior to the sale. In general, a purchaser at an execution sale is affected with notice of all the infirmities in the title of the judgment debtor. Section 230. Interest of mortgage not affected by bidding at execution sale. So it has been held that where a mortgage whose mortgage had been registered prior to the execution sale, but subsequently to the docketing of the judgment, attended and bid at the sale, his interest was not affected by such silence or apparent acquiescence, though had the mortgage remained unrecorded until after the sale, the purchaser, if without notice, would have taken the property freed from the encumbrance. Section 231. Actual notice of unregistered deed. Actual notice of unregistered deed will be as effectual as the formal registration of the instrument, but this actual notice must be brought home to the party to be affected by it. The fact that one of two partners, judgment creditors, had seen a deed from the debtor, who had been allowed to remain in possession of the premises for 2 years, and the deed had remained unrecorded for that time, was not deemed such notice or evidence of notice as would entitle the grantee in the prior unregistered deed to relief. Section 232. Purchasers protected by good faith of execution creditor. However, in the case of Lowe v. Blinco, it is laid down as a rule, deduced from the authority cited below, that a purchaser at an execution sale with notice of an outstanding unregistered title is protected, provided the creditor acts in good faith without notice. The creditor having the right to direct the sale, the purchaser takes all the title the sheriff can be required to sell. Section 233. Equitable interference in favor of holder of unrecorded title. Courts of equity did not always regard purchasers at execution sales as purchasers for value, and have refused to allow a judgment creditor to subject land of his debtor to his judgment in equity after such land had been sold to another, though not yet conveyed, even where the creditor had no notice of such sale, either actual or constructive. Section 234. Creditor's interest held to attach from date of levy. Under a statute making the record of written instruments notice to subsequent purchasers and creditors from the date of filing for record, it was held that in case of levy subsequent to the date of the deed, but before the same was filed for record, a purchaser at the sale under such levy would be protected in his purchase against a grantee whose deed was not recorded until after the levy, provided the creditor had no notice of the deed at the time he directed the levy. Section 235. Unregistered deeds good against creditors with notice. Unregistered deeds are good as against creditors with sufficient notice to put them upon inquiry, and possession by the grantee has been held sufficient notice to creditors, as well as subsequent purchasers and mortgagees. Section 236. Notice of deed must be subsequent to its execution. The notice to creditors should be subsequent to the execution of the instrument. So where one or two creditors of an insolvent debtor, anticipating the execution of a deed to the other creditors by way of a preference, and in fact having positive knowledge that such deed was in course of preparation, sued out a writ of attachment before the deed was delivered, and had the same levied upon the debtor's land before the deed had been deposited for record, but not before the completion of the conveyance. It was held that the title derived under the execution of the attachment would prevail over that under the deed. Section 237. Notice of assignment governed by same principle. So also in a contest between two creditors of a mortgagee, one of them obtained an assignment of the security, while an assignment to the other was being drawn, and made haste to have it first recorded. His diligence in taking advantage of the compliant disposition of the debtor and the deliberate movements of the other creditor gave him the better title to the mortgage. He was not informed of the assignment to the other after it was made, and could not be charged with notice of a fact by information received before the fact was accomplished. The mere circumstance that he knew of his rival's intention to obtain an assignment of the security could give that rival no superior equity, so that his vigilance in being beforehand with the other creditor and getting his instrument first of record was sufficient to give him the paramount right. Section 238. Judgments given precedence over prior deeds. In some instances, the courts, under the peculiar wording of the recording acts of their states, or influenced and controlled by earlier decisions of the same courts, have held that a creditor would not be affected by the registration of a prior deed subsequent to the obtaining of a judgment, or even the contraction of the debt for which the judgment is rendered. Section 239. Deed takes priority if registered before execution sale. The better opinion seems to be, however, under statutes rendering unrecorded deeds void as against subsequent purchasers and mortgagees without notice and for a valuable consideration, and where judgments become liens upon the real estate of the debtor from their rendition, that where a deed or mortgage has been executed and delivered prior to the date of the judgment, the purchaser or mortgagee will be entitled to the protection of the registry laws if his deed or mortgage is filed for record before the sale under execution. Section 240. Judgments do not become liens after conveyance and before registry. So where purchasers and mortgagees were allowed 90 days within which to deposit their deeds and mortgages for record, and a purchaser allowed the time to pass without recording his deed before he had deposited it for record, judgment was obtained against the former owners, and 1A became replevin bail, upon the faith of representations by the judgment debtor that the land was unencumbered, except by the lien of the judgment. In an action by the replevin bail for the purpose of securing indemnity through the means of the judgment for his collateral undertaking, it was held that the judgment was no lien upon the land, for the reason that the debtor had no title to the land at the time it was rendered, and the replevin bail could occupy no better position with respect to the judgment than the creditor himself would have enjoyed. Section 241. Title not affected by recording deed after the title vests an innocent purchaser. The title having once passed through the hands of a purchaser for value, and without notice of a prior unregistered deed, it will pass to subsequent grantees unaffected by the prior conveyance, whether subsequently recorded or not. So where one who purchased with notice and before the unregistered So where one who purchased with notice and before the registration of the prior deed conveys to another who has no actual or constructive notice of such instrument, the title of his grantee is good against the former unregistered conveyance. Should this last grantee convey to still another who had both actual and constructive notice of the prior deed, his title would be good in spite of the outstanding conveyance. Section 242. Reasons for the above doctrine. It would be but a doubtful protection to a bona fide purchaser if his reliance upon the record only gave him a title to the property purchased, which the law rendered inalienable except to those who might be as ignorant of the adverse claim as he was himself before the purchase. The law having declared that the deed was void as to him meant that the title which he obtained should be as absolute and unburthened by the unregistered deed, or those claiming under it, as though no such instrument was ever executed. The title cannot be wrested from him by the negligent grantee, nor will the law allow the value of the property to be diminished in his hands by depriving him of the benefits of a free market. Section 243. Effect of repurchase by fraudulent grantor. But should the premises come again to the hands of the fraudulent grantor, they will be held by him in trust for the first grantee, it being deemed a wrong of less magnitude to deprive the innocent purchaser of this one opportunity to sell than it would be to suffer the perpetrator of such a fraudulent act to enjoy any advantage over his victim. Section 244. Conflicting decisions as to sufficient notice of unregistered deed. There is a marked contrariety in the authorities as to what is sufficient notice of an unregistered deed. This difference in some instances is owing to the different statutory provisions of those states where the question has been adjudicated. In other instances, there are conflicting decisions as to the proper construction of similar or even identical statutes, by which decisions the law is regarded as settled within the jurisdiction of the courts by which they are rendered. Section 245. Express notice required. In some of the cases, it has been decided that nothing short of express notice of the prior unregistered deed will suffice to charge the subsequent purchaser and protect the title of the prior grantee. The information by which the subsequent grantee or mortgagee is advised of the existence of the prior unregistered instrument to be effected must be so direct and positive that to disregard it would amount to fraud on his part. Section 246. Actual or constructive. Others hold that the notice may be either actual or constructive, express or implied, and where actual notice is required by statute, they vary in their construction of the law as to the evidence by which such notice may be established. These latter, in furtherance of the liberal construction given for the benefit of the grantee, whose deed is unrecorded, hold that any fact coming to the knowledge of the subsequent purchaser, sufficient to put a man of ordinary prudence upon inquiry and which, if followed out, would lead to express notice of the unregistered conveyance or claim, is sufficient to invalidate the subsequent deed, notwithstanding the provisions of the registry laws. Notice is imputed to him on account of his negligence in not prosecuting his inquiries in the direction indicated. Section 247. Different kinds of notice referred to. As to the effect of the doctrine of lis pendens, and notice arising from recitals in the conveyances forming the chain of title of the purchaser, and also as to notice by possession, the reader is referred to the parts of this chapter where these topics are separately treated and more fully illustrated by reference to adjudged cases classified under their respective heads. Section 248. Cases holding notice ineffectual against the record. Some of the cases cited in support of the strictest construction of the statute, as Lilliard v. Rutgers and Dewey v. Littlejohns, take the extreme position that personal notice of an unregistered deed will not affect the subsequent purchaser who relies upon the record. So in the case of Mayhem v. Coombs, which was decided under a statute rendering unregistered mortgages absolutely void as to the subsequent purchasers or encumbrances. The court gave the statute such a construction as would render notice by any other means ineffectual. Section 249. Cases holding implied notice sufficient. The cases of Williamson v. Brown, Whitebread v. Jordan, and most of the others cited in support of the more liberal construction go upon the ground that even actual notice is a fact to be established by evidence, and may be proved otherwise than by evidence of direct personal information. They also hold, for the most part, that voluntary ignorance on the part of the purchaser is the legal and logical equivalent of actual knowledge. Section 250. Illustration of implied notice. Musgrove v. Bonser was a case where the deed had been copied upon the records, but because it was improperly acknowledged before recording, the record was held a nullity as constructive notice. But the attorney who was employed by the subsequent purchaser to search the record for instruments affecting the title saw the defective record of the deed in question and informed the purchaser that it had no right on record. Upon the ground that notice to the agent was notice to the principal, the court held that the actual knowledge of the attorney had of the defectively acknowledged deed was sufficient to have put a man of ordinary prudence upon such inquiry as must have inevitably led to the knowledge of the unrecorded deed, and that it was therefore binding upon the purchaser's conscience. Section 251. Any kind of notice will affect purchaser. From a careful consideration of the authorities, old and new, English and American, it seems that the better doctrine is now, except where the statute is imperative in its provisions to the contrary, that any species of notice by which one seeking to purchase real estate is informed of or cautioned in regard to any unregistered instrument affecting the title to the property or any equitable interest claimed by anyone will as effectually bind such property in the hands of such purchaser as it would in the hands of the fraudulent grantor. Section 252. Putting upon inquiry held insufficient. The case of Jackson v. Van Valkenburg is one of those in which it is declared that notice of an antecedent unregistered mortgage upon the leasehold to the assignee for value of a subsequent mortgage upon the fee of the same premises in order to effect his rights under the assignment must be such as would, with the attendant circumstances, be sufficient to fix upon him the imputation of a fraudulent purchase in accepting the assignment. It was held that putting the party upon inquiry was not sufficient. The circumstances of this particular case were such that it may well be doubted whether such notice as the assignee had was sufficient to put him upon inquiry respecting a mortgage, as what he learned from the record of an absolute assignment of the lease, without the defeasance which should have been recorded with it. Section 253. Knowledge of mortgage without from record. Nope. Knowledge of mortgage withheld from record. Where a mortgage is designedly withheld from registration in order to preserve the credit of the mortgagor in the commercial world, such conduct on the part of the mortgagee is not fraudulent as to one having knowledge of the entire transaction, as he is not deceived by it. And whatever might be the rights of a party who purchased in ignorance of the facts, the one who seeks to take advantage of an unregistered instrument, of the existence of which he has been fully informed, will be allowed to enjoy no special advantages from the fact that the failure to record the mortgage was fraudulent as to others. Section 254. Record of instrument affecting equitable interest. The record of an assignment or mortgage of an equitable interest in real estate will operate as notice to subsequent purchasers or mortgagees as effectually as though the legal title were conveyed or encumbered. As where one purchases land for which he receives a title bond instead of a deed, conditioned that the legal title shall be conveyed to him when the land is paid for, which bond is duly recorded, and before paying for the land, the purchaser mortgages his interest, and subsequently the mortgagor, in order to meet the demands of his grantor, executes a mortgage to still another party, and with the proceeds pays for the land and receives a deed. In such case, the release from the vendor's lien inures to the benefit of the first mortgagee and the second mortgagee by the record of the title bond, and the first mortgage is charged with notice of the rights thereby secured. Section 255. Effective withdrawing deed from files before recording. But when, as in the case of Clamorgan v. Lane, the grantee placed his deed on record on the 26th day of the month, and a subsequent purchaser received a deed to the same premises from the same grantor on the 27th, which he placed on record in the forenoon, and the first grantee withdrew his deed from the files to be cancelled, and the acceptor another deed which he deposited for record in the afternoon of the 27th, it was held that the record of the first deed was no notice of the one given in lien thereof, and that the prior purchaser could not claim priority of record after withdrawing the first deed from the files. Section 256. Priority secured by registration. Under statutes which prescribe no time within which the instrument may be recorded, the courts have generally regarded the first recorded of two instruments affecting the title to the same land as the one entitled to precedence, as where a grantor took a mortgage for a portion of the purchase price and entrusted it to the mortgagor with directions to have it recorded, but before depositing it for record, the mortgagor entered into a written contract with another party who had no notice of the mortgage to convey the land to him. the mortgage being recorded prior to the recording of the contract and before the latter was either carried out or brought to the knowledge of the mortgagee, it was held that he might subject the land to the payment of his debt as though the contract had not been made. Section 257. Fraud practiced by agent. It has been held where there was a similar statute to the one under which the case cited above was decided, where the claim for precedence was being contested in a court of equity, that the court would determine the relative rights of the parties on equitable principles. It is difficult to understand how a court of equity could tolerate such a palpable fraud as was apparently perpetrated upon the innocent contracting party in the Ohio case. The mortgagee, by entrusting his security to the mortgagor, not only made him his agent, but did so with the knowledge that he, of all others, was most interested in violating his trust, and by so doing enabled him to practice a fraud upon others. Section 258. Vague information disregarded. The case of Jolland v. Stanbridge, which has been cited as one in which express notice is required in order to deprive a subsequent purchaser or mortgagee of the protection of the registry laws, was a contest between one claiming under an unregistered will and a subsequent mortgagee. The evidence of notice was that the mortgagee was told, while negotiations were pending, that the person offering the premises had no right to sell the same. Also, the evidence of the mortgagee's bookkeeper that the wife of mortgagee told the witness, in the presence and hearing of her husband prior to the mortgage, that the devicee's mother had told the mortgagee not to purchase, as the estate belonged to her daughter. Still, the court held that the evidence of notice was not such as would show conduct on the part of the mortgagee amounting to actual fraud, and gave the preference to the subsequent registered mortgage. Section 259. Subsequent purchase not invalidated by notice of prior deed. Notice will not always invalidate a subsequent purchase, even when it is so direct and positive as to be equivalent to actual knowledge. Circumstances may arise where a purchase subsequent to an unregistered conveyance may be made in such good faith that it will be protected even though the purchaser has undeniable knowledge of the prior deed, as where he is informed by the prior grantee himself that the deed is withheld from the record because he does not intend to assert any title under it, and that it was never intended to operate as an actual conveyance of the land, and the second purchase is made in reliance upon these representations. Section 260. Same doubtful authority. A court of equity has even declared the doubtful doctrine that a subsequent purchaser would be protected when he acted in good faith after notice of the prior unregistered deed, because he had been informed of the intention of such grantee not to record his deed or assert his title where it did not appear that the information came from the grantee himself. Section 261. Record chain of title incomplete. The purchaser may be served with constructive notice by registration, even when the complete chain of title does not appear of record. The connection between the title or interest with notice of which he is charged by the record and that upon which it depends may be independent of the record, as where the provision of the statute was that every instrument affecting the title of real estate from the time of filing with the Register of Deeds for record shall impart notice to all persons of the contents thereof, and all subsequent purchasers and mortgagees shall be deemed to purchase with notice. It was held that one purchasing with notice of an outstanding unregistered equitable interest in land was chargeable with notice of an encumbrance if such interest which had been filed for record, though he may have purchased without actual notice of such mortgage. Section 262. Assignee of a mortgage regarded as purchaser. The assignee of a mortgage will be protected to the same extent as any other innocent purchaser, as where a mortgage was given to secure a debt, subsequent to a deed conveying the same premises to another, but the deed was not recorded until after the mortgage had been assigned to a bona fide purchaser for value, and the mortgagee took the mortgage without notice of the unregistered deed. It was held that the assignee was not affected by the subsequent registration of the deed, but would still be entitled to subject the land to the payment of his demand. Section 263. Time of notice. The time when the notice is imparted to a subsequent purchaser is often material in determining whether or not his purchase will be affected thereby. The notice, in order to affect his conscience, may have been given too long before his acquisition of title to render it probable that the fact of the prior conveyance was present to his mind when he made the purchase. Section 264. Same to attaching creditor. But where land was attached at the suit of a creditor as the land of his debtor, when he had been informed by the grantee 2 years prior to the attachment that he had purchased the land from the debtor, it was held that though the deed to the purchaser was still unrecorded at the time of the attachment, the notice was sufficient and the purchaser's title would be protected as against the attaching creditor. But the purchaser of a mortgage will have constructive notice from the record of a mortgage of even date, though recorded subsequent to the one purchased, if such purchase was subsequent to the recording of the other instrument. Section 265. When notice too late. The notice may also be too late to be effectual against those who subsequently acquire title to the premises or to an equitable interest therein. On this point, there has been no little contrariety of opinion expressed by the courts at different times, partly owing to difference in the statutes, but in some instances the decisions are at variance, where the statutes construed are substantially the same. However, it will be found to be almost uniformly held that the notice is too late if it comes to the purchaser only after he has completed the purchase and paid the consideration. Section 266. After purchase at execution sale. It has been maintained, however, that a purchaser at an execution sale directed by the creditor in good faith after having made the purchase is entitled to his deed, even though he receives notice of a prior unregistered deed previous to his payment of the purchase money. And it is further held that his rights will not be affected either by the fact that he, being a stranger to the execution, had notice of the prior deed, or that he is himself the execution creditor, provided he had no notice before the sale. But should the knowledge of the adverse interest come to him in the way of an announcement at the time of the sale and before it is closed, the title acquired by the purchase will be subordinate to that of the prior grantee. Section 267. Before legal title is conveyed. Upon the other hand, it has been held by the same court in which the above doctrine was announced that a purchaser of land takes subject to prior equities of which he has notice, although the contract is completed and even the purchase money paid before notice is given of the antecedent claim, provided he is notified before his own equity is closed with the legal title, and creditors to whom the title is transferred by operation of law occupy no better position than any other subsequent purchaser. Section 268, time of filing for record fixed by statute. In those states where a certain period of time is fixed by statute within which the instrument is required to be lodged with the officer for registration, the failure to deposit it for record within the time prescribed does not always, as we have seen, operate to invalidate the record. It is, in general, good for all purposes for which it was originally designed from the date of its filing for record, whenever that is after the time prescribed. But it has been decided that a voluntary deed, to be effectual as against creditors of the grantor without notice, should be recorded within 3 months of the delivery of the deed, where that was the statutory time fixed. The statute was construed with the same strictness in favor of a subsequent mortgage given to secure the debt of the husband, where the prior voluntary deed was from the husband to the wife. Section 269, recording after death of grantor. It has also been held that the registration of a deed after the death of the grantor was not good as against creditors of the grantor who had no notice of such conveyance, but the application of this rule would be controlled in a great measure by statutory provisions as well as by the peculiar circumstances of any case in which it might be invoked. Section 270, examining records in sufficient inquiry. A purchaser who, previous to the purchase, is informed of a prior unregistered deed to the same premises, and who searches the records without finding any entry of the prior deed, will not be protected as a purchaser in good faith, merely because he examined the records after receiving information of the prior deed. He should have made personal inquiry from those most likely to possess knowledge of the conveyance, and from the character of the discoveries made in the course of such inquiry, been warranted in believing that no such deed had ever been executed and delivered. Section 271, unrecorded chattel mortgage. Under a statute which rendered a mortgage of chattels void, except as against the mortgagor and his heirs, unless recorded, it was held that such a mortgage was good against an attaching creditor with notice, and also that notice to the officer levying the attachment was notice to the creditor by whom the attachment was directed. Section 272. Description of debt in mortgage. In some cases, considerable strictness has been required in mortgages to render their registration effectual in the description not only of the property encumbered, but of the debt thereby secured. In general, however, more recent decisions have favored such modifications of the rules in regard to specification of the amount of debt and the nature of the evidences thereof, that mortgages to secure future advances are permitted when the amount to be secured is necessarily uncertain. It is held in the latter case, however, that the record of an assignment of a mortgage will not be noticed to subsequent purchasers because it is not required to be registered. It is laid down in Jones on Mortgages, section 365, as the English rule with respect to notice as it affects mortgages for future advances, that notice to such a mortgagee of a subsequent encumbrance will render any advances made thereafter subservient to the lien of the second mortgagee. But such does not seem to be the rule in this country.